Good evening, call sir.
Good evening, ma'am.
Good evening, everybody.
Good evening, sir.
Sir.
Cindy, you are also there?
Yes, sir. I'm your
Oh
student.
my
How
God.
can I miss your lecture, sir?
Huh?
How can I miss your lecture, sir?
Oh my God. I am not lecturing today. We have a lawyer, senior lawyer, who's going to lecture to you.
But sir, you are our guru. You always remain one.
Oh my God. I'm an old man now.
Not
Forgotten
at all,
everything.
sir. Not
More
at
the
all.
wisdom. More the
Huh?
wisdom.
Good evening, call sir.
Mr.
Good
Mathur has
evening, Mohit
joined.
sir.
Good
Good
evening,
evening.
Mohit, sir.
Good evening. Good evening. Hi.
It's a privilege to have both Professor Call and Mr. Vikmath together on the same platform. And it's my privilege because I've learned both of them. So thank you very much,
You
sir, for
are
being here.
actually you are actually stealing what I was about to say. I was about to say this only. I was about to say that call sir has been my guru. I mean, taught during my BLM days, and similarly, Mohit sir has been Dr. Parikshit Sirohi's guru when he entered into practice. So when we
Absolutely.
decided to hold this
We
program,
are the real gurus. Huh? We are artificial gurus. They are the real gurus. They teach you really what the law is.
So,
सर
sir,
हम लोग तो है गिवन सिचुएशन के ही सब मास्टरी करते हैं. आप लोग सारी सिचुएशंस की मास्टरी करके बताते हैं.
I have heard your father when I was in very active practice earlier. It used to be a treat to hear him. I know how difficult cases he used to make easy. And I've seen you also now as I'm in the profession, so I see you every day dealing with so many complex matters and make them very easy. So I think the real knowledge about how the law works is with all of you.
और how to work around the law.
I'm happy that you are also commanding the same respect your father used to command from the
अरे सर,
bench and
That's-
bar both.
that's sweet of you, sir.
यही होना चाहिए. This is what how the legacy should go on.
Sir, we can just keep on trying.
I
Ultimately,
remember 1975-76. Justice Ansari was the Chief Justice of J&K High Court. And he came one day to Delhi High Court and he said, I am looking for Mr. Dinesh Mathur. He had some difficulty in some matter, I think he wanted to. So I said, okay, now that you have these judges all coming again, back to the Pathshala, Mathur Sahab ki Pathshala. So
अरे
that
सर,
is we're really looking forward to your wonderful guidance day in an area which is very, very difficult for students because we always teach them only abstract of it.
नहीं सर, perhaps the only area in which I am good at.
Miscellaneous work is the work in the High Court.
True. True, sir. It occupies a lot of time also. It takes away a
Yes.
lot of time. Regular work hardly reaches.
Yeah. So miscellaneous work is very satisfying because either you get the relief of the client or you don't get the relief of the client, but he knows what is in store for him.
Yes, I think
Yeah.
miscellaneous work also takes away a large part of the time because we have lengthy processes. The clients are generally most of the time requiring that short-term reliefs and those something to keep them consoled and keep them going.
Because they know that hearing in the appeals will take a lot of time, you know. It takes
That's true.
years and
Okay.
years together. I remember when Justice Kaul was Chief Justice of Madras High Court, and there was a judge, Justice Nagamuthu, who is now practicing in Supreme Court. He dealt with the appeals, criminal appeals. I think he finished all the pending criminal appeals that were lying. And everybody was very happy that because he used to do that in batches, you know. I think somehow they had evolved certain practices where they would dispose of a batch of matters together. How it was working, I
So
do
that's
not know.
exactly what our Justice Justice Sodhi
Yes.
was
Delhi
there.
High Court.
Delhi High Court. He did the same thing. He finished off. He collected like one statute. He'd pick up 100 cases of that statute, try to compile them. If they're the same legal issue, then have them 20, 30, whatever, joined together.
And that is the way I think if you are able to sort it out that way and get the matters disposed of, I think that is one of the ways of doing away with the arrears also. And people also feel that, you know, there is access to justice and there's at least end to the litigation.
But Professor,
Sir,
the thing that one needs to also understand is that the judges who sit to dispose of should have a large heart.
Yes.
Because when you are dealing with old cases and batch
Yes,
of cases,
yes.
you should be basically tilting more towards the citizen rather than towards the state.
Correct. And that
Sir,
is
our,
basically the
professor in
edifice of the
charge,
criminal jurisprudence.
Yep.
Mr. Roy, we
sir,
were talking
professor,
time.
no, I'm so
I'm
sorry, sir. No, I didn't mean to interrupt, sir. Our professor in charge is here because I know both of you
Oh,
are
very
extremely
good.
busy. So we will just request sir to welcome and
Yeah.
formally start the program. Professor
Yeah,
Mahavir Singh,
Before
sir.
he welcomes us, we welcome him to the.
Professor Mahavir, sir.
Yes.
Sir, I apologize. There is some technical problem. Let me
No
just
problem.
call him.
Oh,
Yes,
he's
he's here.
coming. He's
He's
coming.
here.
Is there?
Yes.
Good evening, Professor Mahavir Singh.
सर नमस्कार
Good evening, Dr.
Nice to see you.
वेलकम
Are you at Gaon in your office?
नहीं सर मैं गुड़गांव हूँ
अच्छा, Gurgaon.
आज ऑफिस में नहीं हूँ
Sir, we don't have internet in office, sir.
हाँ, yes, sir.
अरे फुर्सत आ-
वाईफाई मिलता नहीं सर वहाँ तो बिल्कुल भी तो इस पर डिपेंडेंट रहना पड़ता है ऑफिस भी कहाँ है उनकी ऑफिस है ठीक और कैसा
बहुत अच्छा। देखिए आपने बुलाया और हम चले आए।
सर आप मालिक को बताओ आपको बुलाना पड़ा ना आपका तो हमारे ऊपर आप कह रहे हमारा आपके ऊपर बहुत ज्यादा क्योंकि आप बड़े हो
बिल्कुल इसमें कोई शक ही नहीं है।
तो
This is my center, yeah. This is I
आज
spent
दिस इज your
35
center, sir.
years, 36 years of my life
राइट सर राइट
in that center.
तो सर आपने आपका बड़प्पन है सर और ये आप तो इस सेंटर की क्या दूसरों को भी कोई भी आपको बुलाता है तो आप तो खुशी जाती हो सर हर एक जगह एंड
I was in the National
You are-
University, Delhi.
you are really,
I was there. in
ऐसा
the-
है you are not asset for the family or asset for LC2 asset for faculty of law but entire society.
Oh my God.
We always find you everywhere.
Thank you.
तो ये तो हमारा सौभाग्य है सर कि
Good to see you.
आप उतने समय दिया और ये आपका अपना सेंटर है सर तो देखो आप तो
Hello.
आप तो 35 की बात कर रहे हो सर हमने तो बहुत बाद में यहाँ ज्वाइन किया बहुत बाद में सब
I know when you joined. I know when you joined.
बस तो सर
आज माथुर साहब को बता रहे हैं हम, देखियो लॉ सेंटर 2 का कितना अच्छा फ्रेटर्निटी है हमारी. That all these many of them have been our young students, they are our colleagues, then they are today they are our mentors also.
सर ये तो ज्यादा हो गया.
सर वो पॉसिबल ही नहीं है.
आईटी में इतना आता है, हमें तो कुछ इंटर वगैरह
तो ऐसा मेंटर तो आप ही रहोगे, हैं? और तो
शुरू करें.
sorry, sir, we are okay. First of all, thank uh, for the opportunity and organizing this webinar, seminar, panel discussion. तो हम कह सकते हैं इसको, चलो we are honorable, distinguished, our two guests, our esteemed colleagues and students present here for this panel discussion. Very good afternoon or good evening to all of you. I'm sure that all of you know that today the good has been the standard of same purity. Why I want to use the word you use the word gold, because we are celebrating our golden jubilee. Plus two. So that I'm starting that I'm sure that all of you know to fact good has been the standard of purity and excellence since time immemorial. And I'm very happy to be the part of milestone of Law Center 2 for the celebration of its golden jubilee. Law Center 2 celebrating its golden jubilee 2021-22. We have already successfully organized a number of programs, events, and activities, and we are on our way to create a road map for the future generation. In the continuance of celebrating the 10th Golden Jubilee year of Law Center 2, today we are adding one more event in our Golden Jubilee celebration. Law Center 2, a long, proud, and distinctive history. It is one of the distinct centers of Faculty of Law, University of Delhi. Law Center 2 was founded in the year of 1971. The premises of ESG provide quality education while offering full-time LLB program. Today, Law Center 2 is a Golden Jubilee Center, continues to be a progressive center, made a strategic commitment to the higher quality of teaching and research. It is a premier institution and is known for its qualitative teaching, research, and other co-curricular and extracurricular activities. The center is a hub of research, learning for law students, to promote students' activities at center. A number of committees have been constituted, like moot court committee, debate and seminar committee, journal committee, legal aid committee, assessment committee, and alumni committee. The center had the privilege of being headed by the top law scholars of India, such as Professor Upendra Bakshi, Padam Shri Award, well-known jurist and former Chancellor of University of Delhi, Professor Tahir Mahmood, basically in the Chairperson Minority Commission, Professor A.K. Cole, was elevated as Vice Chancellor NLU Jodhpur and NLU Ranchi. Professor Gurdeep Singh Bhari, who became the Vice Chancellor NLU Lucknow. Professor B.T. Kaur served as Chairperson Judicial Academy. Professor Puram Saxena is presently Vice Chancellor and Jodhpur. Center has the privilege of having alumni from all parts of life. Law Center 2 is celebrating 50 years of teaching. The center has grown exponentially in footprints, academic office, and student body. Today, number of alumni center are contributing in the future of India. The alumni included senior bureaucrats, police officers, revenue officers, doctors, engineers, chartered accountants, company secretaries, politicians, etc. Some of the alumni include His Excellency Honorable Governor of Himachal Pradesh, Brigadier Mr. Sri B.D. Misraji, Sri A.J. Alphonse, Member Rajya Sabha, Activist for Tourism, Justice B.D. M, Justice Kailash Gambhir, Justice Sandhya, Justice Rajiv Sakta, Justice V.K. Rao, Mr. M. Damodaran, Chairman, Ex-Chairman SEBI, Mr. G.D. Geha, Mr. Manoj Kumar Sinha, Director, Indian Law Institute, New Delhi. Many more legal luminaries. Law Center 2 has been publishing two journals named National Capital Law Journal and Daily Journal of Contemporary Law, publishing quality research in the field of law and contemporary issues. I feel proud to be currently associated with Law Center 2. My dear students, colleagues, non-teaching staff, everyone associated with Law Center 2. We have pushed thousands from and tenacities, and today it is a time to celebrate, to introspect, and to consolidate, and to plan for LC2's future. Today, we have this speaker and well-known speaker, Professor B.T. Kaulji, and as I got mentioned, Professor B.T. Kaul is so renowned professor, so renowned intellectual, so renowned researcher, scholar, that he doesn't need any introduction, because as himself, Professor B.T. Kaulji told us, he spent 35 years of his life at Law Center 2, Faculty of Law. It's Professor B.T. Kaul who obtained his LLM in 1973, LLM in 1975, and PhD 2007 degrees in law from University of Delhi. He was a Foreign and Commonwealth Fellow at London School of Economics. University from there, he earned second LLM degree in 1986. He has also been appointed Intellectual Property Organization, fellow at workshop on teaching and research in intellectual property, at Sydney, Australia, jointly organized by World Intellectual Property Organization (WIPO) and the University of New South Wales, Sydney. He was invited by the Honorable High Court of Delhi to head the Judicial Academy as its chairperson, which position he joined on 12th of May 2014 and continued to hold the said position till 11th of May 2008. Earlier, he was professor of law and professor in charge of Law Center 2, Faculty of Law, University of Delhi. Professor B.T. Kaul has teaching experience in the field of law of four decades. As the chairperson, Delhi Judicial Academy, he gave new impetus to judicial education and training at Delhi Judicial Academy, improving quality and quantity of programs for judges and other stakeholders. He wrote social context adjudication, a special program for all the judicial officers in Delhi. In the program, judging to justicing, of which one of the components was clinical trial, human rights of the participants.
So can you increase the volume, please?
Pardon?
Volume, please increase the volume. It's not audible.
मेरा वॉल्यूम तो वैसे इसकी जरूरत नहीं पड़ती।
Sir, I think that's your end because then we are to
एक मिनट,
we are able to
Mahavir sir, we can hear you.
इससे
Yeah.
ज्यादा तो नहीं हो सकती सर।
सर ये वली साहब के एंड पे प्रॉब्लम हुई।
हाँ मैं
Sir, now it's okay.
Okay, sir. Other was clinical trial and human rights of participants. Other programs that we introduced subjects like gender justice, child rights, environmental law, intellectual property law, human rights, and cyber law in the judicial education and training programs in Delhi Judicial Academy. Increased programs of Delhi Judicial Academy for judges from other parts of the country and also some of the shark countries. We initiated the process for setting up quality infrastructure, including furnishing of hospital, video conferencing, starting residential training programs at Delhi Judicial Academy campus. In his capacity as Professor of Law, Faculty of Law, University of Delhi, he was Director of Placement Cell, Faculty of Law, University of Delhi, and also editor of the prestigious legal journal, Daily Law Review, and convener of the Admission Committee of Faculty of Law for a number of years. Professor B.T. Kaul has been contributing to the labor law literature on a regular basis. He has been authoring a chapter on labor management relations law in the annual survey of Indian Law Institute, a prestigious publication. Daily for Indian ILI Daily for more than 3 decades, and also contributed a number of other writings in the area of labor law and criminal law in various leading legal journals and books. He's a regular resource person at National Judicial Academy, Bhopal, State Judicial Academies, and National Law Universities across the country. He's also resource person with degree, National Labour Institute and the Indian Law Institute, New Delhi. He is also member of Research Board, Advisory Board, and Academic Council, respectively, of some of the universities. He was a member of expert committee set up by Ministry of Home Affairs, Government of India 2008 to examine suggestions made by the department related Parliamentary Standing Committee on Home Affairs. Its 128th report of the Code of Procedure Bill 2006, so far as they related to the summons and warrant cases and summary trial procedure. In the year 2014, he was Chancellor's nominee in the research committees for appointment of Chancellor of National University, Odisha. He was appointed as a member of expert committee, Dr. Jubilee committee, set up by the Ministry of Health and Family Welfare of India to formulate policy guidelines and sought for approvals of new drugs, clinical trials, banning of drugs, 2013, and the report submitted by the said committee as a substantially been accepted by the Ministry of Health, Family Welfare of India, and have been incorporated in the Schedule Y to the Drugs and Cosmetic Rules 1945, named under the Drugs and Cosmetic Act 1940. Professor Cole is a member of National Expert Committee to address the issue of 40 case the hip implants manufactured by Mrs. Deepoy International Limited UK under the chairmanship of Dr. Arun Agarwal, Professor of ENT, MAMC, New Delhi, constituted by the Ministry of Health and Family Welfare of India. Professor Kaul is a member of committee to address replacement gelatin capsule with cellulose capsules by the Ministry of Health and Family Welfare of India. He is a member of Central Ethics Committee of Indian Council of Medical Research and Human Clinical Trials. He is also member of Fortis Escorts and NCPR Independent Ethics Committees, respectively, for the last number of years. He joined legal profession July 2019 and practices law in Delhi High Court and Supreme Court of India. Sir, we welcome you on today's program at your own home, because in your own family. So that's why that you are always remembered, and we will remember for your constant inspiration to our teachers, for giving constant inspiration to our teachers and students. And welcome you in your family of LC2, and it is a proud for LC2 that we without any hesitation, we always ask you, always ask you to guide us, and today again we are waiting and welcome you for your address.
Thank you.
Next, eminent speaker, today's program, Mr. Mathur, Senior Advocate and President of Delhi High Court Bar Association. He is third generation lawyer. His father, Sri Dinesh Mathur, also is a leading senior advocate and was 6 times president of Delhi High Court. While his grandfather, late Sri Tarachand Mathur, was a legendary criminal lawyer of Delhi, both of the pre-partition and post-partition eras. Mr. Mathur had been a good student and a national scholarships holder during his school and college days. After finishing his graduation in mathematics honors from St. Stephen College, Delhi, he completed his degree from Campus Law Center, Faculty of Law, University of Delhi in 1990. Here, he was elected as president of PLC Students Union. He started his practice under the league of Sri G. Ramaswamy, the then Attorney General for India. And after 3 odd years, he started his independent practice in different courts in Delhi, from trial courts to Supreme Courts. He efficiently handled cases in the various fields and slowly shaped into a specialist in the field of criminal law, especially economic offenses and special statutes. He held the many path-taking cases. He was designated as senior advocate by the High Court of Delhi in 2015. He is popular leader of the High Court Bar, having been elected as honorary secretary of Delhi High Court Bar Association in 2011, and then in May 2019 as its president. Sir, we are luckiest enough to have you here, and I welcome again and again on the behalf of Center family at our Law Center 2. Thank you, sir. Thank you, and for guiding us and for coming here. So our students as well as our teachers are waiting. So I won't like to become any hurdle between the two. So we'll make a request. Sumiti to pay honor to our two eminent guests and request them to deliver their intellectual talk. Thank you.
Sure, sir. Thank you, Professor Mahavir, sir, for the introduction of our guests. I would now like to welcome Professor B.T. Kaul, sir, to please address everyone. We are eager waiting for both guests. Yes, please, sir, just address.
Thank you very much. It's a pleasure to be part of the Golden Jubilee celebration of the Law Center 2 and the centenary celebration of Delhi University. I think these events are very important in the life of this institution, and all of us part and parcel of this great institution, and I'm very happy to be back in this great institution. I am grateful to Mr. Mohit Mathur, President, Delhi High Court Bar Association, to have agreed to share this platform with us. It's a pleasure to hear him in court, outside court. I'm sure this platform is going to be very rich when he delivers his very, very educative talk, which is absolutely practice oriented, and I'm also very eagerly waiting for that event. I am grateful to Professor Bhavi, Professor in charge was too, for being so kind. He has in fact read whole of my short biodata I had given. I said, please prune it and make it too small so that you can do it in 2-3 minutes. I think he read the whole of it. I think it has been almost like a lecture on all. Thank you very much. Thank you, Sir Sirohi, Dr. Sirohi, for reaching us, for bringing us back at the advice of your PIC. Same to Sumiti Ahuja. I can see that she was a lovely student. I still remember I could not give her admission in the university, but she had to go to her master's.
Sorry to interrupt, sir. Used to remind me this thing always when we used to take our classes in ILI.
Then I would like to
Yes.
So I'm very happy that she has shown her mettle and she is now a part of the faculty in Delhi University. I'm very proud of her. I could see two of my other colleagues, seeing Chennai Yadav. She's also here, very, very wonderful student of mine. And I also see Narendra, Dr. Narendra. He was here. I saw him on the screen. So I'm also thankful to a very senior lawyer, Mr. Jubilee, part of this operation today. Also, I see Justice Kumar from Kerala on the screen. I'm thankful to him for taking time off from his busy schedule. He's writing very important books on criminal procedure. And in fact, I have learned a lot of things from him on criminal procedure law from him. I'm thankful to the faculty members for coming and sharing today's event with us. I'm also thankful to the students. I'm also thankful to the attendees of today's webinar. I think I will not take much time except give some background to the development of the law of bails. But I think most of the practical aspect of it done Mr. Mathur, because that is his specialization. And I would also like to trace, as I see, you have written about the evolutionary development of the law bails. So I thought I should deal with that part of it. I'll like to recall Justice Nariman in one of the very famous cases, I think, which Mr. Mathur must be using every day in and out, is Nimesh Tarachand Shah versus
Nikesh.
India, and it become one of the
Nikesh Tarachand Shah.
Yes, it is Nimesh Tarachand. It is 2018-11 SCC page 1, which has drawn this history and evolution of law. I think I've taken a lot of material from his judgment, and I find it very useful for today's discussion. So therefore, I will start from what Justice Nariman has done a lot of research on this, and I think I should benefit from his research, which I would like to share with my colleagues and my students today. And you see his research in that he says that the provisions of the bail law go back to the Magna Carta. Because in clause 39 of Magna Carta, if you read, it says, no free man shall be seized or imprisoned or stripped of his rights of possession or outlawed or exiled, except by the lawful judgment of his equals or by the law of the land. Now you can see Magna Carta of, I think, 13th century, and that again, development of that takes place And he says that the next milestone in the English history is the Bill of Rights of 1689. When it says excessive bail ought not to be required. Now, this is an expression which is used in the Bill of Rights in Chapter 2, Clause. From there, you have a very important thing to learn from the history. And that is the Clause 39 of Magna Carta was subsequently extended to pre-trial imprisonments. Now, this is the most important part which I want to say. It's pre-trial imprisonments. So that the persons be enlarged on bail to secure their attendance for the ensuing trial. It may also be added that 1 century after the Bill of Rights, the US Constitution borrowed the language of the Bill of Rights, and the principle of habeas corpus found its way in Article 1, Section 9 of the US Constitution, which was followed by the 8th Amendment of the Constitution, which expressly stated that excessive bail should not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. In Constitution does not have provision like 8th Amendment. But if you read the judgment of the Supreme Court, Raja Kumar vs. State, which is 2011-13 SC 706, the court has read 8th Amendment in Article 21. And the court has said, I'm quoting what Supreme Court says in this judgment, our Constitution does not have similar provision. But after the decision in Maneka Gandhi's case, now that was the watershed in the development of the due process in India. Jurisprudentially, the position is virtually the same. And fundamental respect for human dignity underlying the 8th Amendment has been read in our jurisprudence. Now, this is the proactive role that the Supreme Court started taking after the Maneka Gandhi's case. But it is a beauty about the judiciary on the whole, which I am going to demonstrate to you, which you go to the judgment of Sibia. When you go to the Constitution of Gurcharan Singh Sibia versus State of Punjab of 1978, again, I think in 1980 SC 565. That judgment to draw the historical development of the law bails, Supreme Court has referred to various High Court judgments, starting with 1924. And that is why I said, since you are talking about the evolutionary development of the law bails in India, it is very important to see how the courts have, at the level of the High Courts, from the very beginning of the 20th century, dealt with this aspect with the seriousness that it deserved. I'll trace only 4 cases. One was a case in 1924 of the High Court of Calcutta. And that case is Narendranath Chakrabarty, in which the Calcutta High Court explains the object of bail. Now, that is what we every day see being talked about by Supreme Court in the judgments, and we cite it every day when we appear in the court or we go to the classrooms to teach to our students as to what is the purpose of the bail and what is bail. Object of the bail is to secure the attendance of the accused at the trial. And the proper test to be applied is the solution of the question whether bail should be granted or refused, and the test is whether it is probable that the party appear to take this trial, and that it is undisputable that bail is not to be withheld as a punishment. A very important statement, Calcutta High Court in 1924. The two other cases that are referred to in Sibia's case are what are popularly called, famously called, mere conspiracy cases. These are of 1931 of the Allahabad High Court. One is K.N. Joglekar versus Emperor. It is AIR 1931, Allahabad 504, where it was observed while dealing with section 498 of the old code, which corresponds to the present 439 of the new code, 73 code, that it conferred upon the session judge or the High Court wide powers to grant bail which were not handicapped by the restrictions in the preceding 497 corresponds to section 437. Now, 437 talks about power of the courts other than High Court and Sessions Court and police officers to grant bail. It was observed by the court, and that is what is important, and that's why I'm referring to this case. It was observed by the court that there was no hard and fast rule and no inflexible principle governing exercise of discretion conferred by 498, that the only principle which was established was that discretion should be exercised judiciously. Now, this case was also followed by a case called Emperor versus H. Hutchinson. This is AIR 1931, Allahabad 356. It was said that it was very unwise to make an attempt to lay down any particular rules which will bind the High Court, having regard to the fact that the legislature itself had the decision of the court unfettered. According to the High Court, the variety of cases that may arise from time to time cannot be safely classified, and it is dangerous to make an attempt to classify the cases and to say that in a particular class bail be granted, not in other classes of cases. An accused who enjoys freedom, now this is why we say presumption of innocence, because when we arrest a person, we say presumption of innocence unless proved guilty beyond reasonable doubt. An accused person who enjoys freedom is in a much better position to look after his case and to properly defend himself and than if he were in custody. And that's what we always say, that the first thing that must look at is, will he be able to get a fair trial? Will there be a fair trial in this case? As a presumably innocent person, he is therefore entitled to freedom, every opportunity to look at his own case. A presumably innocent person must have his freedom to enable him to establish his innocence. That's what we talk about every day. Now this is, I was talking about pre-constitutional era. Now we come to the constitutional era where we have a judgment of justice in Gudi Kanti Narasimhalu versus state. This is 1978 1 SCC 240. I think all good cases that were decided by the Supreme Court were decided in 1978. Maneka Gandhi was decided in 78. This case was decided in 78. Motiram was decided in 78, to which I will refer later on when I come to Motiram's case, because to me it's one of the very, very jurisprudential, having a jurisprudential importance in respect of what amendment was brought in 436 and incorporation of 436A by virtue of that, what was that, Husainara Khatun in 2005 in the Criminal Procedure Code by way of the amendments. I'll come to that later on, but let me talk about this case. The issue of bail is one of liberty. Now, this is the first thing we talk about when we talk about liberty of a person on Article 21. Justice, public safety, and burden of the public treasury. Now, these are various conflicting claims which have to be dovetailed. How to balance security of the society? How do we balance the liberty? How do we balance the justice? How do we balance the burden on the public treasury? All of which insist that a developed jurisprudence of bail is integral to the socially sensitized judicial process. After all, personal liberty of an accused or convicted fundamental, suffering lawful eclipse only in terms of the procedure established by law. And in terms of the Maneka Gandhi's case, procedure established by law is due process, where the procedure has to be fair, just, reasonable. Law has to be just, fair, and reasonable. The last four words of Article 21 are the life of that human right. Now, that is where we must understand the jurisprudence of law bails. Then there is a judgment of another case, I think Justice Goswami, in Gurcharan Singh's state, Union Territory of Delhi, which is 1970 again, and that is referring to what his concept of is. There cannot be, and this is how he wants the law to be developed. The judge's discretion must not be curtailed in a way that you do not have what we call as a proper judicious decision in the matter. That is why he says there cannot be an inexorable formula in the matter of granting bail. The facts and circumstances of each case will govern the exercise of judicial discretion in granting or cancelling bail. It is clear, is what we must look at. The question whether to grant bail or not depends upon answers to a variety of circumstances, the cumulative effect which must enter into the judicial verdict. As any one simple circumstance cannot be treated as a universal validity or as necessarily justifying grant or refusal of bail. Now, this is where we have naturally to look at when we talk about this position. I just wanted to go to Moti Ram's case, keeping in view Indian situation that exists today, when we find who are maximum people who are languishing in jails are not the convicts, it is the under trials. It is not the rich, it is the poor. It is the people who have been granted bail, they do not have the sureties. It is the people who may have surety, but they don't have the sureties. Or it is the victims like who the victim in Moti Ram's case. I'll just like to deal with this case in a very short, but I would like to appeal to the sensitivities of our students, teachers, judges, lawyers. And that is what I learned from Moti Ram's case. The Supreme Court has held, this is Moti Ram, that bail covers both release of a person on his own bond with or without sureties. The question whether sureties should be demanded and what should be insisted upon are dependent upon variables. The Supreme Court in Moti Ram's case, although it shocked one's conscience to have asked a mason like the petitioner before it to furnish a surety of 10,000 rupees in 1977, when the rupees value was very high. And I think a lecturer at Delhi University, I joined in 78. I was getting a salary of 1,086 rupees. And if you ask me to give a surety, which is my 1 year salary, perhaps I would also not have been able to give that surety. The court observed that the magistrate who asked to furnish surety must be given the benefit of doubt for not fully appreciating that our constitution enacted by we the people of India is meant for the butcher, baker and the candle maker. And shall we add the bonded labor and the payment debtors? Not only this, the magistrate demanded surety from his own district, while as his brother, whom he produced as a surety, had property in another district. The disconduct of magistrate again earned wrath of the court, and after a detailed discussion, court came to the conclusion that sections 441, 2 and 3 use the word bail generically because the expression is intended to cover bond with or without sureties. The court in circumstances directed the magistrate release the petitioner on his own bond of rupees 1,000. But it took Motiram to walk into the statute book from 1978 to 2005. But at least it has gone into the statute book in 2005. And you have a 436 amended where a person can be released on his discharged on his personal bond. And when should he be discharged on his personal bond? If he's an indigent person. When is he an indigent person? If he is not able to, have a surety for 7 days. Now, this is a very important jurisprudence, which I think we must be very familiar with. And the second aspect that I would like to take up is 436A. And those are the cases which evolved because of the public interest litigation, like Hussain Ara Khatun, where now there's a statutory provision. 436 says if a person has spent half of the time, which is the maximum sentence, for an offense as an under trial, then he shall be discharged on his personal bond. Now, this is a very important development that has come into the criminal procedure code, and I think this we must teach to our students with all the, our sensitivities that we have and the sensitivities that we must create, because tomorrow when they become lawyers, they become judges, they understand the importance of section 436A. I would like now only to go, because rest of the things I would like to leave for Mr. Mathur. I don't want to take everything that has to be taught. I like only to say something on two aspects. One aspect is anticipatory bail, and second is default bail. I'll refer to only two cases, and I am done with it. One, I would like to tell you the situation in which Sushila Agarwal versus State 2025 SC1 came before the Supreme Court, a constitution bench of Supreme Court, 5 judges bench, and it was to reconsider CBI's judgment in the light of the deviations that had been made by smaller benches of the Supreme Court, and to see whether it should depart from CBI's judgment or it should uphold CBI's judgment. And luckily, I think it adopted the approach taken by CBI and took a lot of guidance from the judgment that has been delivered by CBI. And I think CBI is itself a very locus classicus judgment. The two questions. Before that, for the purposes of bail, I would say to my students, please read Arnesh Kumar. Because Arnesh Kumar brings in the perspective which is required to be brought in the classroom. The development of the law by virtue of the 2009 amendment to the Criminal Procedure Code. By amending section 41 and by adding section 41A. I will not deal with it, but I am sure my colleagues, young colleagues will take it in the classroom. And Arnesh Kumar says, the disgust the court has towards the way, it says it's one thing to have the power to arrest, it is another thing to exercise that power. I think it was said by the Supreme Court earlier with respect to the judicial officers also in Bhatti's case, where it said it is one thing to have the power to grant bail, but it is another thing to exercise that power. Now this is what Arnesh Kumar will tell you. Arnesh Kumar says, as bringing humiliation. Arrest curtails freedom. Arrest scars forever. Even if you are acquitted, those scars will not go away. So therefore, arrest is a matter, exercise of which has to be cautious, and the demand to be granted by the magistrate has to be again a judicious process. Now that I will not take up much, but only just I don't know how much time I have taken. Have I taken more than?
No, sir.
Required? I'll just take 10 minutes only. 10 minutes.
Sir, please take your time, sir. No problems.
Just
We are
like
fortunate to have you, sir. Take your time.
I just like to say there were questions which Matre's judgment referred to the larger bench. And the two questions were whether the protection granted to a person under 438 is with anticipatory. This power is to be exercised only by the Sessions Court and the High Courts. Should be limited to a fixed term so as to enable the person to surrender before the trial court and seek regular bail. Now, some benches had taken the view that once a person gets an anticipatory bail and he is summoned by the court, then he must go and surrender before the court and apply for the regular bail. Now, this is in that context that this question arose. Second, whether the life of an anticipatory bail should end at the time and stage when the accused is summoned by the court. I'll just like to take on the concept of what is anticipatory bail. And that is what Justice Shah has brought out very beautifully. I'll just like to draw your attention to what he observes in 7.1 of this judgment at page 36. A person in whose favor a arrest order is made under 436 or 38 CRPC has to be arrested. However, once there is an order of pre-arrest bail, anticipatory bail, as and when he is arrested, he has to be released on bail. Arrest memo has to be drawn. Now that's what I think my very experienced friend Mr. Mathur is going to tell us more about it. Otherwise, there is no distinction between pre-arrest bail order and 438. The bail order under 437 and 439. The only difference between so that normal anticipatory bail is a normal. It is not that you are granted a bail and therefore it will be a bail, you will not be arrested. No, it is only in the event of your arrest, you shall not be arrested. And this is what he is explaining, and this is very good to be explained to our students. So they have very good grasp of what anticipatory bail and how it is different from 37 to 39 bail. The only difference between the pre-arrest bail under 438 and bail order and under 437, 439 is the stages at which the bail order is passed. The bail under 436 is where his arrest and in anticipation of his arrest, and the order of under 437, 439 is after a person is arrested. That's why when you move an application before the court for anticipatory bail, and if you are during the pendency of the anticipatory bail and you have not got an interim order from the court, you are arrested, it becomes a premature. In fact, it becomes infractious. The bail anticipatory application becomes infractious. A reading of 438 shows that there is nothing in the language of section which goes to show that the pre-arrest bail granted under 430 has to be time-bound. The position is same as is in 439. And final conclusions that given in this case are, I think I should, regarding question number 1, the court holds protection granted to a person under 438 should not invariably be limited to a fixed period. It should endure in favor of the accused without any restriction on time. Normal conditional 437.3 read with 436 should be imposed. There are facts and features to any offense. It is open for the court to impose any appropriate condition, including fixed nature relief or it being tied to any event. As regards the second question referred to this court, it is held that the life or duration of the anticipatory bail does not end normally at the time and stage when the accused is summoned to the court or when charges are framed, but can continue till the end of the trial. Again, if there is any special or peculiar features necessitating the court to limit the tenure anticipatory bail, it is open for it to do so. Now, this is where I thought I should deal with some aspect of the anticipatory bail. Now, I'll just like to quote only one case. That case is relating to 167. That is what we call as default bail, and I think we will have more on this default bail from Mr. Mathur, but I'll just like to say how I appreciate the work done by Justice Lukur and Justice Gupta. Of course, they in that judgment of Rakesh or of Assam, the court says it is an indefeasible right. If once the period of 60, 90 days is over, challan is not filed, you have to grant the bail even if the offense is a heinous offense. Now, the best part of it is the court is earlier is the session court or high court keep the matter pending till they file the challan, and then they'll say that the challan has been filed, therefore the application becomes infractuous. Court said nothing doing. Once that period is over, whether it is pending or not pending, it has to be granted. This right of all has to be granted, and it operates any bail. The second important aspect of this, which I wanted to take up, is that even an oral request, you don't have to move an application. Even if an oral request is made to the court, it is sufficient request for the purposes of 167(2), and the person can be granted default bail by the court. I think this is how court is slowly but gradually moving towards human rights jurisprudence and protecting the rights of the accused at appropriate stages wherever there is a laxity on the part of the investigating authorities in filing the challan. Now, these are some of the ideas I just want to share with you. Rest, I think, bundles are going to come from Mr. Mathur, and we will all be greatly benefited by his great history on the subject. I'm sure Justice Rakumar is there. He'll all in the would like to give his thoughts on the subject. Thank you very much. Thank you all. Thank you, Dr. Mahavir Singh. Thank you, Mr. Parikshit. Thank you, Jyoti. Thank you, everybody, for patiently listening.
Yes, sir.
And I hope I have been able to do some justice with the topic, if not complete justice with the topic. Thank you very much.
Thank you so much, sir. Just one thing before I invite Mohit, sir. Sir, it is the richness of your lecture. They've always admired you, your lecture to the way you explain the things, the way you take us through the cases and explain the entire development of the law related to a particular topic. It is always very enriching. Thank you so much, sir. I mean, we always look forward to hearing you. We always.
Dhanyawad, sir.
Thank you. Thank you very much.
Thank you, sir. I would like to invite Mohit to address the gathering, to address the attendees and apprise us about the practical aspect of it. If sir, please, sir, if you could.
Thank you, Sumiti.
Thank you so much, sir. Yes.
Although not much is left for me to say, just call the word almost the entire length and breadth. Professor B.T. Kaul, chairperson, former chairperson, Delhi Judicial Academy. Professor Mahavir Singh, the professor in charge of the Law Center 2. Dr. Parikshit,
Thank you, sir.
Sumiti, the faculty members,
Thank you, sir.
Justice Ram Kumar ji, and I too saw my colleague and elder brother, Mr. B.L. Wali, on the screen once, but I think he stopped the screen. Students, faculty members, ladies and gentlemen. In fact, rather than Professor Mahavir Singh ji welcoming and thanking us, I feel it an honor that I am in some way or other I am made a part of the Golden Jubilee celebration of Institute, which now is housed in RCLC.
We're all one.
Sir, we have a different building, sir.
The precincts are the same. That's where we used to have our chai and spend our time.
Yes.
When I told this talk and I told so that Professor Kaul is going to be there, my first query was, will I get a chance to speak? Because I was sure that Professor Kaul will cover most of it. But I get an advantage. Professor Saab's elucidation of law and my applying it in courts on a daily basis. That's slightly different. And I'll just try to share my experience and my way of looking at this subject with the permission of the dignitaries on the attending this. Sir, just since you have already covered the evolution with the description of Magna Carta and Bill of Rights, something which we keep using and which judge us today, we can say that most of the lawyers will be using it and must have used it before him also. And that is, bail has to be understood is only the transfer of custody. So, as Professor Kaul said, that it's not that you're not going to be arrested or you're not in custody. It's only that your custody gets shifted and transferred to somebody else becoming your bailee. With the undertaking, as on the practical side, some which students never actually learn in the colleges, but are suddenly thrown, they are filed bail. What people don't realize is even the bail bond is a part of the code. It's what we call as Form 45, which basically asks the surety to undertake to bring the person to attend the hearing and the trial. So all that the bail does is the transfer of the custody from what we call as from Sarkari Man to the custody of the bailee. So one cannot actually think that once he's been granted bail, he is a partly liberated and a partly free man, not a completely free man. And for that very reason, there are some intrinsic conditions that he needs to follow and he needs to obey with. Though the code distinguishes between different sections in the chapter on bail and bonds, 436 being only for all bailable offences, 437, 439 being seeking regular bails either from the magistrate or under 439 with the superior courts under the code, that is the session or the court. Both have concurrent jurisdiction. There is practical difficulty, and it's very set. I don't want to detain everyone. I want this to be understood and to be taken note that when there is a concurrent jurisdiction, there is a tendency on the theory side to feel that one should rush first to the higher. Either because I am practicing there, so I will take the client to the high court, or for other reasons that High Court generally and by and large has been more liberal when it comes to the concept and release on bail. But most of the courts and most of the courts have in practice directions always insisted on approaching the sessions court first, because that way, one, the load is divided for the High Court, and secondly, they get the chance of opinion by the session court, which helps in coming to a conclusion. 439, the judgment which was pointed out by Professor Kaul in Gurcharan Singh, AIR 1978, Supreme Court, page 179. I also have benefit of the counsel who argued that matter, teaching me the concept of law and bails in my own house, since my father was also one of the persons who addressed arguments in that. Interestingly, that's a case on cancellation of paragraph 1824 of the AIR citation, the entire law on bails has been elucidated. And something which is missed out by many is in the paragraphs in judgment, the Supreme Court dichotomizes section 37 and says that the restriction under 437 on grant of bail is only to cases where there is imprisonment for death or imprisonment for life. And Supreme Court beautifully says that in all other categories cases, bail should be granted. We have a tendency of hyping a case today because of the social media. But otherwise, the law has not categorized these cases separately. Categories are based on the punishments imposed. Severity of any case or any offense by the severity of the punishment.
Details.
It is not because 100 crores are involved or 1,000 crores are involved or 10,000 crores are involved or 420 offense. The sentence is only 7 years and it is triable by magistrate. That classification of an offense also governs who will grant bail and who is likely to grant bail. Theory apart, we must understand exclusively sessions trial cases, by and large, bails are not granted by magistrates. Some magistrates may be bold enough that may be your luck, who may say that from prima facie I look at the offense and the allegations, session trial case is not made, those charged grant bail. But on the practical side of it, it's very unlikely that they will touch it even with a pair of tongs. So you have to accept it. That's exclusively triable by sessions as per the classification or under special statute if they are exclusively triable session. 439 is the remedy. Another thing which one must bear in mind is that the conditions which can be imposed on release bail is under 437(3), which are only for cases which are above 7-year sentence, not below 7-year sentence. Somehow, the courts as well as the lawyers, in their haste or in their exuberance in somehow getting themselves released on their clients released on bail, they forget that conditions are imposed which are otherwise impermissible. Because the only provision for imposing conditions before a magistrate is under 437(3), which is only in cases for sentences 7 years or upwards. However, having said that, 439 is a separate class altogether where there is provision put condition, but inherent in these sections. They can impose the conditions while they are granting bail. And 438, and just adding to what Professor Kaul said, and I'm building only on that, borrowing whatever theoretically he has said, absolutely there is no word like anticipatory bail in the code. It is grant of bail when you are apprehending arrest, and that too in a non-bailable offense. The accusation must be of non-bailable offense, not of a bailable offense. So you seek an order of release on bail in the event of your arrest. Just adding that clarification to Professor Kaul's treatise on it was that it is order, a pre-arrest order, that as soon as you are apprehended or arrested, the arresting officer or the court concerned will direct your release on such terms as are either enunciated in the order or to his satisfaction. Another interesting part, since much of the development of and evolution of the bail has been discussed, is that the old code, as was mentioned by Professor Kaul, of 1898 CRPC, which we inherited from British, never contained any provision for anticipatory bail. This is a new coinage, and not even celebrating his golden jubilee. It came into effect in the 73 code from 1/4/1974. So we are yet to cross even 50 years. LC2 is older than the original anticipatory bail.
70 years.
So anticipatory bail actually came in because Law Commission found there was a conflict of judgments, and once Punjab and Andhra Pradesh, Punjab held that the provision of 497, 498 actually included in it an order of release of bail even before the arrest has taken place, whereas Madhya Pradesh High Court differed on it. So, with different high courts have different views about it, the Law Commission actually undertook that exercise because there was a reasoning given that it would avoid unnecessary incarceration and plus certain strategic complaints. And why I'm using this word strategic complaints is because Gurbakh Singh Sibia, as cited by Professor Kaul, was a case of political rivalry. And it was in that context that the Supreme Court laid down 8 different principles. the ruling, then failing judgment of the Punjab Haryana High Court, which Supreme Court introduced for the first time the concept of Article 21 and discussed how the person's liberty was to be protected. In fact, something which we as lawyers keep harping, and many times it falls on deaf ear because the order comes with a small dismissal, is the part that earlier bail and liberty of an individual was given prime importance. But over the years, and with the complexities of the commercial world and the other offenses which have come up, especially drugs, etc., there has been a curtailment on the liberty that was otherwise commonly being given. Now, those liberties are also curtailed in special statutes like the SC Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, where they have done away with the provision of anticipatory bail. So in case you need to challenge and seek and secure your liberty, you need to basically develop an argument for quashing of that and approach under a of the current and approach under jurisdiction, 482 current jurisdiction. Similarly, in economic offenses and in offenses which affected the security of the nation, riders were imposed to the otherwise, or what is commonly called, as Professor Kaul talked about, Nikesh judgment, is the conditions. The conditions are over and above the parameters of bail. Because till the time these from TADA or UAPA or from NDPS, when these twin conditions started coming in, before that, the only criteria, and Gurcharan Singh's judgment, which people have noted, AIR 78 Supreme Court, categorically said that the paramount considerations, and the language used by the Supreme Court of paramount considerations for bail are the likelihood of the accused tampering with the evidence or hampering the investigation, and his likely absconsion, or whether he is going to be available for trial or not. Over and above this were the twin conditions imposed that the courts will have to come to the conclusion that there is no of his case against him, or that he is unlikely to commit such offense if released on bail, to make it harsher and stricter for him to climb that ladder. In appropriate cases, courts have come to the aid of the individual, but these conditions are imposed in such a manner and are so strict that it leaves very little scope for bail. Now, again, as I said, Professor Kaul had covered up all judgments, Emperor, etc., all covered, which take care of the oft-quoted line that defense counsels say that bail is the rule and jail is an exception. And just to add to what Professor Kaul mentioned, 78 was in fact a very good year for people of seeking liberty, not just Simalu and Charan Singh, Babu Singh and Harsh Sahni. Miss Harsh Sahni's judgment also came in those very years. Justice Krishna Iyer at his best, and then comes Gurbakh Singh Sibia. Actually, very few judgments going to benefit the accused. I'm honest, the judgments, Gurbakh Singh Sibia was only being actually not referred in judgments of Salahuddin, KL Verma, etc. They took the point of the anticipatory bail is only for the purpose of investigation, and once the sheet filed, cognizance taken, it is the domain, exclusive domain of the trial court. On that basis, Supreme Court, in a few judgments, limited the duration of anticipatory bail. And as on the practical side, everyone sees, one judgment of Supreme Court followed by 100 of the different high courts in a span of 1 month, and that's it. People's fate is sealed. Nobody looked at Gurbakh Singh Sibia. What it said, it actually said that the bail shall endure till the end of the trial. And that was then taken up in Satlingappa Mahatre's case by Justice Dalvi Bhandari. Actually, we had the benefit of him on the bench in the Delhi High Court, and he had taken this view despite Salahuddin in the High Court, and we were lucky that he went to the Supreme Court, got elevated to the Supreme Court, and there he got the chance, and on the first given opportunity, he used his compilation, which he had used in the High Court, and this judgment was delivered. Followed by Bhadresh's judgment, Bhadresh Bipin Chandra's judgment of Supreme Court, where the 10 points are quoted. And the last 10th point is a very interesting point lawyers use daily in some sort or the other. And as law students, you can read it and it's very interesting. It says if the court comes to the conclusion that the case is frivolous or is malicious, so it's so wide that if one wants to grant the relief, you actually can take shelter on that cause. It allows that if you show inconsistencies in the case of the complainant and the frivolity of the complaint, you can secure an order of pre-arrest bail. Somehow gets glossed over. So finally, Sushila Agarwal's judgment, another 5-judge bench, though it was considered only one part of the Gurbakh Singh Sibia's case, but it reaffirmed. Now, there is something which I wanted to also highlight. We are trying to look at anticipatory bail, regular bail in a balance of scales. What we miss out is Arnesh Kumar's judgment was cited by Professor Kaul. It is actually preceded by Justice Venkatachalaya's judgment of 1994, Jogendra Kumar's state police. Actually, that was on reforms. And it was a guidance to the police that don't go and arrest everyone merely because there is a case. And that's where they used the phrase, borrowed the phrase, that mere power of arrest doesn't justify the arrest. And on that's what today, even going to write to Arthur's judgment of 2021 of the Supreme Court, and then Satinder Kumar Until's judgment, which has now a couple of clarificatory orders also which have come, where the investigation can be concluded without arrest. There is need for arrest. In those cases, there was a concept of whether section 169 and 170 CRPC actually require person to be arrested and then sent up trial charge sheet, or charge sheet be filed without arrest. On different occasions, different courts have taken different views. Delhi High Court fortunately has always held the view that if you don't need it, file the charge sheet without arrest, and there's no need for anybody to be arrested. bail can be granted on a currency. A re-judgment, again, before it was proper understood and clarification could judgments passed, that the Supreme Court is distinguished economic offences. But actually that was not so. There was a clause D, category D, which economic offences. Now, economic offences doesn't mean cases which involve commercial transactions. That was again clarified by the Supreme Court in December order on an application, that we have not drawn any categories for this purpose. We actually have asked you to make more liberal. This entire exercise was to make bails liberal, more liberal, courts granting bail liberal, not to curtail the freedom of the person. So what one needs to understand is, over the years, where bail the rule, jail is an exception, only for special statute, things were carved out and special restrictions were imposed. If they are not imposed and the general law is to prevail, then we have to go back to the locus classicus of Gurcharan Singh and others. And so, in fact, I was smiling when Professor Kaul was mentioning about 10,000 surety. Sir, I had occasion, while I was digging into this evolution of bails, of a 1930 law case, where it was down by Krishna Pal, where the condition of bail was 10,000 rupees. And when they went in for cancellation, that was the ground taken by the High Court, that if you put a condition as high as 10,000 rupees, where is the question, where is the likelihood of him running away? So on that basis, dismiss cancellation bail. They said to make an exceptional. Now, when bail is granted, the Supreme Court says cancellation has to be based on a supervening circumstance. And or some violation of the same also holds for anticipatory bail. What's happening is, wherever there is a large number of investors and the court feels that the impact of such a crime or such an offense is affecting a larger section of the society, they have deprecated the practice of anticipatory. So we are actually narrowing the aperture, and slowly and gradually, one judgment after the other, a line creeps in, which as a counsel I can always say is obiter. A judge probably might himself bound by it, and a professor only has to speak what is written in the judgment, cannot comment on it. But these lines which creep in generally say, grant anticipatory bail in exceptional cases. But that was not the diktat of Gurbakh Singh. It never limited grant of anticipatory bail. All that it required was that the court should be satisfied.
Judicious exercise.
Yes. That exercise of judicial discretion was left to the superior courts. And that is what Gurbakh Singh Sibia says, which will miss out. We only go for the conclusion. But please see the reasoning why the judges have come to that conclusion. The judges say 438 is granted only to the superior courts and not to a court of a magistrate. So it is, you have to attribute that much judicial discretion and that much wisdom that they know to grant relief, not to grant it. Sir, there is also an aspect which you probably touched only in the passing, and on 167.2, The locus classicus on 167(2) of default bail is Anam J. Kulkarni, 992 Supreme,
Yes.
which again talks of the fact that you can keep me in custody and then decide when to conclude your investigation. So what we need to understand is anticipatory bills which see are on the fear, that threat and apprehension. Regular bails are actually when you have suffered the custody. A very common argument all students law will find in judgments when they read are that the man has suffered custody, police remand was obtained for a number of days. Now he is in judicial custody, nothing remains to be recovered from him or at instance. He is not required to be interrogation, therefore bail is granted. So what one needs to understand is custody is sought or is permissible under law only if man is likely to be not available or he likely to affect your investigation. So you want him out. Like a tadipa, you keep him out so that the law and order is maintained. So investigation is being threatened to keep it. But if your investigation by him complete, you are now working on a different aspect, then he can be released on bail. And that is the concept even for default bails, that a reasonable period is given, that sentences up to 10 years, 60 days are given for you to investigate after the arrest. And 90 days in serious case, life death. If you see a pattern, bails are restricted, and like in a recent judgment of the Supreme Court, in GST cases, the court said that don't grant anticipatory bail to such offenders. But it is not the law that you cannot grant them anticipatory bail. It's because GST as a legislation is like any other revenue legislation where the government exchequer is involved. And in fact, initially there were a few judges trying to begin just for the lecture, but discussion could not. There is an old 1974 Act which came along with the Act of the Criminal Procedure Code, and that is Economic Offences Inapplicability of Limitation Act. And there were 15 economic offences which were mentioned there. Only those were treated as economic offences which were in that schedule. Today, anything which has an economic angle to it is being misconstrued as an economic offence. 468 of the CRP, the old prints, if somebody can get hold of, had a statute inapplicability of limitation, Economic Offences Inapplicability of Limitation Act. The present books and publishers don't publish that schedule. Only those Income Tax Act, Foreign Exchange Act, Customs Act, there was an inapplicability of the limitation, and they were construed as affecting the economy of the state. So there was inapplicability of limitation. Even if the limitation on the statute, the intent the statute was less, the limitation would not apply. Because you can't just tear it out. And what is torn out of the context also is an old judgment of the Supreme Court, 1987 Supreme Court, Mohanjit Porwal's case. The line used in Monjit Porwal's case was economic offences are done with a calculated mind. A murder may be committed in the heat of or passion. So we treat economic offences separately. But it is incorrect usage. That was a judgment on recall of a witness on 311 CRPC. It did not deal with bail or the case. It only gave the state an opportunity because they said economic offenses are done with a calculated mind. So allow them one more opportunity to call the witness. Unfortunately, Mohanjit Porwal's paragraph is now used in Y.S. Jagannath Reddy's case with that same very line. And now it has become a part of curtailment of your bails in economic offenses. So over the years, we have only seen bails becoming more and more difficult. An anticipatory bail is like climbing a hill. It's a Herculean task on its own. Whereas legislature itself is finding it tough. And the courts, along with the police, are issuing practice directions and the standing orders. Otherwise, even offenses like 406, 498A, matrimonial disputes, people were being sent behind bars. So in a case of one Punia, a standing order 444 issued by Delhi police on the direction of the High Court. I arrest everyone in the family immediately because of the complaint. So in the evolution, actually it's not been a very happy evolution as far as defense counsels are concerned. The evolution has only narrowed further the scope for bail. So perhaps an topic have been to the starting back to the old regime where bail was considered a normal thing. In all common law countries, the yardsticks are the same. But somehow, while we were relying on the British judgments and the House of Lords judgments, in the 90s, from Anil Sharma's case, the word custodial interrogation started coming in. That was the first time when custodial interrogation word crept in, and it has become today the sword in the hands of the investigator who will just write one line that the custody of the person is required for his custodial interrogation to recover that. Absolutely contrary to the judgment of Harsh Sahni of Supreme Court. Harsh Sahni's judgment, it was state Delhi administration versus Miss Harsh Sahni, where the Supreme Court said that even for recovery of a document or something, you don't need the custody. Person not be detained in custody, you can take that person to get the things recovered. And same has been considered in Gurbakh Singh Sivia. But unfortunately, not one line in ED versus Anil Sharma, only because it was a high profile case, trial by media. That's the sad part. That the trial by media has made it so difficult for even a common man, because what happens is old saying, hard cases make bad law. Now that creeps in for a commoner. And as Professor Kaul right said, those wishing jail, not the people, they will use the law, if I may be allowed to use the expression, to their advantage. And most of us on criminal law are being engaged to use it. The poor man suffers, though there were some beautiful judgments, like N.R. Khatun was mentioned. There was a series of judgments of common cause, where there were blanket directions, sweeping directions for release of under trial prisoners after a period of
Bhim Singh was also one of the judgments.
Sir, they said that if the sentence up to 7 years and he is served 2 years, release him. If it is up to 10 years and he has done 3 years, release him as an under trial. You must have the reason to detain a person. If that reason is not there, don't detain it because you want to detain the person. Or that you just don't like his face. So that can never be the ground or the reason for continuing with it. Something which I just wanted to add, there is often a problem which comes on the practical side. And that is we somehow mixed between the laws applicable on special statutes and the general law. When you are dealing with bails, unless the special statute specifically deals with the provision of bail, like Nikesh Rachan dealt with section 45 of PMLA, where the bail was considered. Section 37 in NDPS Act deals with bail. Unless and until those provisions deal with bail, the general law has to apply, must apply. Principles were elucidated by Professor Kaul. I don't need to repeat. So I would only say it's been a happy evolution. So, the only good thing that has happened over the years is introduction of Article 21, the concept for bail. That is understanding that liberty, personal liberty, is a very, very prized thing. It should not be just done away with on the asking of even the investigating agencies, and they have to justify why they need the custody. So with that, I'll say thank you very much. And theory is learned, but the actual fun is in applying it. So when you these are actually the really practical issues where you will get judgments on after the issues, and you will have varied. So keep in mind, another diktat of the Supreme Court, bail order is not a precedent. It is not a judgment, it's only an order. So you will have to build your case yourself, again in the facts and circumstances of the case. Thank you so much.
Thank you, sir. Thank you, Mukti. Although I have been teaching, for the last 25 years, and I have got good opportunity to hear practical lawyer like you. But really, I enjoy it today because without any without any education, how did you explain? How did you make it so beautified? I'm really indebted, and will remain indebted. Family of LC2 will remain indebted for sparing yourself and giving your costly time at the center. Thank you.
Thank you for giving me the opportunity, sir. Thank you.
Thank you, Mohit sir. Indeed, it was a very educational lecture, very enriching lecture address, and I'm sure about this that all the attendees and more so our students would definitely have some insightful takeaways from your address today. Thank you so much. And now I would request, because today amongst us we do have Honorable Mr. Justice V. Ram Kumar, former Judge, High Court of Kerala, with us. I would request you, sir, if you could address us at the gathering, please.
Sir, you are
Sir, I
mute.
think you're on mute.
You are
Yes,
on
sir.
mute.
Sir, you are muted. Please, if you could.
Sumiti, can you please unmute Honorable Justice Ramkumar? Yeah, I think it's done.
Sir has unmuted the audio.
Can you hear me now?
Yes, yes, sir.
I,
You're audible.
I had an internet failure. After that, I got some speech problem also after my second COVID attack. That is why I have stopped all my webinars. My voice cracks. So I have switched over to book writing. And no wonder I have chosen the right
Sir,
person
you are a star on
for-
the internet, sir. We all see your videos on your
for
YouTube
writing
channel.
the foreword. In fact, I have chosen Dr. Professor Call as the dignitary to write the foreword for my first maiden venture.
Oh my God.
I have not made any mistake in that. Very elucidating and fruitful articulation today. In fact, as rightly said, this Gurbaksh Singh had to be resurrected by Sushila Agarwal. Even though it was way back in 1980, nobody noticed the expanse and the sweep and amplitude of that verdict. In fact, on economic offences, the case arose from Punjab High Court. Punjab and Haryana High Court, they had laid down, they had enumerated 10 or 11 grounds on which anticipatory bail can be granted. Ground number 7 was, in economic offences, anticipatory bail cannot be granted. That was the view by the full bench of the Punjab High Court. It was specifically dissented from
Yes.
in Gurbaksh Singh, but unnoticed. Even in recent P. Chidambaram's case. In Chidambaram's case, Gurbaksh Singh was not applied. In fact, a subsequent smaller bench decision was applied to reject anticipatory bail to P. Chidambaram. Gurbaksh Singh was not. I don't know whether it was cited or not. Gurbaksh Singh specifically dissented from ground number 7 court judgment. In the same case, Professor Kaul, you are a past master of all branches of law, and Rohit Mathur also did a wonderful job. I only wanted to highlight one aspect there. You rightly said bail or jail. It was the motto of Justice Krishna. Even when he was a judge in Kerala, he reiterated that from the Supreme Court also. Then I have one doubt. The Act 25 of 2005, the Amendment Act of Section 438 was amended. Has it come into force?
No, sir.
No.
Sir, the notification, gazette notification, because I 38, which did not include Section 438 amendment, which was the amendment in the Act.
Very
was,
sad. Very sad. In fact, it ought to have been notified. It ought to have been brought into force.
That clause has not come into force.
Yes. And as you rightly said, it does not mean that there is no detail. He transferred from the custody of law to the custody of his sureties, who are jailers of his own choice. Sureties are jailers of his own choice. So he is only transferred from the custody of law to the custody of his own jailers. Instead of being confined within 4 walls of the prison, he is transferred to the custody of surety. That is why he is subject to the overall guard of the court.
Control.
Right? A person, you can't say that a person, when he is granted bail, he has been set off, has been acquitted. Not again. He is transferred from the custody of law to the custody of his sureties, who are only jailers of his own choice. Very beautiful evaluation of the subject. I am grateful to all of you. Thank you.
Thank you. Thank you. Thank you.
Thank you, sir. Thank you, Justice Ramkumar-ji, for joining us. Thank you.
Thank you
Thank you
so
very much,
much,
sir.
sir. Just one thing I would like to add on here to what Mahavir sir was saying. We at LC2 are extremely privileged today because if everyone would have noticed, we have had one academician, someone from bench, and all 3 of them are exceptional perspective views. So We actually are privileged and honored today that in this webinar, our students are getting to learn so much. Thank you so much to all the speakers.
And
Thank you so much.
Sumiti,
I'm literally honored.
And Sumiti, just to add to what been mentioning,
Yes.
Mr. Kumar is a star on the internet.
Yeah.
His YouTube
I am
channel
honored.
is so
I am only a
popular.
small speck in the ocean of law.
No, sir.
I have also,
you-
I have also been, one of the participants in his webinars.
sir.
Yes.
Framing of charges, preliminary inquiry,
Yes.
appellate provision,
Bail,
CRPC,
bail. Yes,
law of
for
bail. So
three
many
lectures.
sessions.
like-
I am sharing my knowledge and experience free of cost to the entire legal fraternity in the country, whole country.
Very good.
That is the one
I
advantage
advise
of
all
COVID.
students to hear his YouTube, these lectures because it's so beautiful.
Thank you, sir.
Thank you, sir. As expected, there is a huge amount of questions. No, there was it time. Our speakers, extremely busy persons, Professor Kaul, Mahavir sir, and Mohit Mathur sir. Everyone has a very busy schedule. We had promised them we'll wind up by 7:30. But if they permit, I would just like to take at least
Go
4 or
ahead,
5
go ahead,
questions.
go ahead, go
Yeah,
ahead.
yeah, yeah.
Take your time.
Thank you.
yeah.
Mr.
Thank you.
Mathur
Yeah.
answer all the
You-
questions.
Sir, we have got to succeed, we got there to learn.
Sir, it
And
is
we learn more and more. It's it should be a never-ending practice. It's good.
it
I
is
have no
it is
problem. I
sir,
have
it
no
is very
problem,
dangerous.
provided our guests are not having capacity of time. Rather, we'll be feeling good opportunity if they will be feeding us.
They have enjoyed being with you.
appreciate fact. But for me, that it's good for center, good for our for students as well.
Sir, it is rather dangerous actually because Mr. Mathur, as we know, is very, very sought after, and the kind of fees he charges, I think all of us put together for that lighter rate. I will just request Harshit Sharma, who has raised his hand, to please put forward his question either here or in the chat box. Then we will go to the others, please. I think-
So first of all, thank you so much for such a intellectually stimulating session, and actually a pass from 21 session. So I've been practicing in Kakaduma code for the past 6-7 months. And so the practical aspect of bail is something that I find to be very different from what we have actually read. Be it our bail bonds, be it verification of bail bond, and till the verification is concluded, the person who has actually secured bail in his favor is language in the custody, which kind of sounds very against the law to me. So that is one thing that I've seen. And sir, in another case, I would just like to share, just like Mr. Mathur said, it was under POCSO Act. One of our colleagues had applied for bail, and he was denied the bail because judge said that what are the different circumstances that arose between the first bail and the second bail. And so the matter was the prosecutor. It was a case under POCSO Act. And the prosecutrix had not appeared even after sending summons to for 8 times. So the POCSO judge, the special magistrate, ASJ, denied him bail, asking him what are the circumstances that has changed. So these are some of the things that I found very difficult to comprehend, because if the prosecutrix is not coming for 6, 7, 8 days.
Harshit, can I just answer this? Because
Yeah.
if you remember, I said, yeah, what you learn in your law college is too different in the course.
That's right.
Yes, sir.
Now,
Yes, sir.
one thing which you don't learn is the whichever high court you practice, or under whichever state you practice, there are high court rules and orders of that state. Now, what you people forget is that bond be a part of 45 of the RPC, but the process of accepting those bail bonds and putting it on the registers. There is a in Delhi High Court rules and order. There is volume 5, which deals with the registers. Now, if you see those registers, those registers have to be filled by the people who are furnishing bail bonds. When the High Court fills those bonds, he needs to confirm whether that verification, whether that address is correct. Now, who's going to testify to that address? So that is why in certain cases, the magistrates, rather than accepting your testimonials which are given, they seek a police verification of the testimonials
Yes, sir.
if they have doubt. So your languishing in custody for an additional day or two is generally on the administrative difficulty. It has nothing to do with the law. So if you have an order which reaches you, because the release warrant, if it reaches you in by 3 o'clock, your registers can be filled by 4 o'clock, and by 4:30 dark, as they say, from district court goes to the jail or the relief person. There is a second dark which goes at 6 o'clock. And if you are feeling aggrieved that there is likelihood that it is going to get delayed, my advice to you is first learn that there is a system of special messenger.
Okay, sir.
Sir,
So
we
you
saw
are-
the same problem in Shahruk's case. I think this problem was
If I ignore those cases,
Yes,
different
yes.
cases make bad law.
yes.
And also, as far as your second aspect is concerned about POXO,
Yes, sir.
if any, it is not just POXO. Subsequent bail application, you have to justify why you have come the second time and not onto the superior court. See, going to the same court again. Now, on the practical side, you are choosing benches. You feel a new, fresh ASJ may be better and giving you a relief, so you go there. But that is not the solution. The law requires you to find out if there is a change of circumstance. If the prosecutor is not, remedies are available. Let what he should have. Merely her not come, not account for you to grant bail.
All right. Thanks so much.
Yes, sir.
You have to seek the remedy, proper remedy for that.
And so just one last question, if Mr. Panel permit, with regards to the default bail under 167(2). So we know one of the co-accused and the counsel for another co-accused, after 2.5 years, said to the magistrate that they still not have a legible copy of the charge sheet, that they were supplied a defective copy of the charge sheet. So, sir, at that moment, a question arose that the defective charge sheet in charge or in ineligible.
207 is not ground for 167(2).
So, like you said, if the charge sheet is not filed within 60 days or 90 days, so my question is this: if someone files a defective charge sheet or ineligible charge sheet, so would that be considered as an obstruction?
There is a judgment called Tundabaja, TUNE. Their name is GBAJA, authored by Justice Ravinder Bhatt. Since you practice in Delhi, I think that judgment will help you. That talks of an incomplete charge sheet.
Okay, sir. Thank you so much, sir. I'll just look it up. Thank you so much, sir, for answering my question. Thank you.
Yes, sir. Sir, I think this question is also related towards you, and this is by a senior colleague of ours, Dr. Avekta Verma. She, of course, like many others, is complimenting our panel for the excellent talk they have given. She says that the judiciary has given laudable judgment to do justice while granting bail. Many guidelines have been laid from time to time. She said trials of the accused start the moment he or she approaches a lawyer. No guidelines for charging fee in bail matters. Lawyers charge according to paying capacity, seriousness of the case. Also, I may add, according to the standing of the counsel. There is no regulation of fee. Next comes judicial discretion, which is, of course, very wide and rightly so. But see that at times this is not properly exercised. Can you suggest a reform to streamline these aspects?
There are two aspects to it. One, I take it as a compliment that the lawyer community is flourishing. But I beg to differ from the person who's asking the question. Perhaps he or she has not gone down, tried to practice. The difficulty is there. Only few people are able to charge the way we hear. It's a handful. And we have more than 1 lakh lawyers in Delhi alone. How many do you know are charging exorbitantly?
Only 100.
So the client's travails don't start there. The client's travail starts with the Jugaad technology. They want to have a Jugaad for everything. They want everything done with the guarantee and an assurance. That's where the problem comes. Now, as far as the reforms are concerned, the best thing is having at least my High Court. Also donning the hat of the President of the High Court bar, I have the advantage of being party to these activities. The Delhi High Court Legal Services Authority has included almost 50% of seniors have undertaken to pick up a case whenever given to them by the legal services authorities. So it's not that the services are not available, provided if you go to the legal services authorities, which are there in every district court, they have a panel of lawyers. And as far as High Court is concerned, we have been able to acquisition the services of even the senior counsel, designated seniors, who have assured taking up cases. And each one has been marked cases to argue whether it be a writ, the labor cases also, the service matters also, and matters also. So it's not good legal services not available. You really have to fend for it. You can't just theoretically think about it. It's on the practical side, and I'm sure other high courts are following suit and must have been, may have even pioneered it. Some high courts are, the seniors are available. And even as far as our high court pro bono activity is almost 10 to 15% of everyone's cases are pro bono. They are, it's not everyone is asking the clients to pay.
From personal experience, I know a lot of Mr. Mathur's cases are pro bono. Not
Forget
even
mine.
today.
I'm talking of senior. They're in association with the legal services. They are doing it. So legal reforms, it doesn't require some kind of a legislation to come, because if you bring in a legislation and make it binding and not morally binding, if it's morally obligatory, then it comes from the heart. If you try to bring in shackles, people will find a way. So that's my way, my take.
It's rightly put, sir, because there is a law on CSR, and we all know how CSR law works, the 3% of profits law. So thank you, sir. This one is for Professor Paul, and this one is coming from Mr. Abhishek Kaushik. And he says, we have read in the news about Supreme Court granting bail to Mr. E. Perivan, the convict in Rajiv Gandhi assassination case. And he says that he was already declared a convict, trial is not pending, decision is on the mercy petition, and this time, instead of parole, bail has been granted. So under what provision bail has been granted is not mentioned in the order. Should we treat it as what is law in regard? In pendence of mercy petition, is it equivalent to appeal by convict? Is he fulfilling the requirements of 389 CRPC, or is it SC under the inherent powers, something like 142 maybe?
I think this is more to do with the pendency of mercy petitions.
That's right. Right, sir. Thank you very much, sir. Sir, there is one more
and
question.
The exercise of power is under 142.
Yes.
142, that's what. In fact, this morning we have read in the newspaper, 142, the CAT, if the vacancies are there, the judges can continue, the members can continue till such time the new members are appointed.
This was done earlier also with other tribunals. So I think now, I think tribunals have become it's a failure exercise of the
serious problem, because the vacancies are not being filled. So, sir, there is one last question, and sir, this is again for you, Professor Kaul. If possible, and Mr. Mathur can also add, if possible, the approach towards excess of power warrant of arrest, judiciary, bureaucracy, these areas, especially with related to economic offences cases. So we see today there is an IS officer in Jharkhand, and huge amounts of money from being found from her, and all kinds of other things. So what should be the approach in such cases?
think this is also happening in. I think Mr. Athur has already referred to these matters. One is that when it comes to the question of socio-economic offences or special legislations, we're finding difficulties in applying the rule of bail is the rule, is an exception. I think it's a matter which needs consideration at some level, but the fact of the matter is that more and more, economic offences are being legislated, and more issues are coming up. But every offence you call anything to socio-economic is not a socio-economic offence. Mr. Babar referred to it, but perception is still with some of the judges that still continues, and that is the perception which I think Arnesh Kumar will apply to some extent when we deal with the police.
Yeah.
What will apply with the judiciary? I think Mr. Mathur will answer that better.
Mr. Mathur, would you
President Bitbolji, I don't know in criminology, once we were discussing the topic of capital punishment, we taught and read, sir, that whether you want to retain or abolish the capital punishment. Here, Justice Bhagavati very forcefully argued that we should not retain the capital punishment in our society, because the heinous crimes are to be happened because of the heat of passion, etc., because of land feud, sex dispute, etc. But if you want to retain it, offenses, he categorically said that if you want to retain, you are happy to retain the capital punishment. Retain it for the white collar criminals, because they are eating the society very silently and invisibly.
So that's a different perspective.
I think one of the things that I'm seeing over time, we are getting more and more capital punishment in many of the, sexual offences you find. You are everything that you want to do is punish it with capital punishment. So I don't see any future for capital punishment getting abolished in the country. I don't see it. I think it's coming with a bang back. May not be with that bang in the socio-economic offences, but I think in other offences it is coming up with a big bang.
Sir, the problem is that the country doesn't subscribe to reformative theories. It's subscribing more to the deterrence theories. So capital punishment is unlikely to go away from here.
Yeah.
And with more and more special offences which are created, especially dealing with the unlawful activities, whether it be terrorism, earlier to STADA, now UAPA has terrorism added to it, and the other offences where the sovereignty is involved. I don't think, especially with the deterrence concept even creeping into bails, that for deterrence purposes, though we may be having the salutary line of bail not to be withheld, punished, but they are detaining the people, especially these builders. Cases you see the past 10 years, and 2013 when the building this building mafia nexus and all political nexus has been in question. The builders are not getting bails only because they say कि बाद में पता नहीं whether they'll get bail, they'll get convicted or not. They will come inside.
Oh, what a stimulating discussion, I would say. When I was inviting one of my former colleagues who used to work with me in Mr. Mohit Mathur's chamber many years ago, it is now 14, 15 years ago, for this program, he said, and I quote, "You cannot acquire knowledge about bail. What is there to do a seminar bail? You cannot acquire knowledge about bail without actually doing bail matters." He went on to give an example. You are an Air Force officer who has never flown a jet. So this gentleman did turn up for some time and I think he had to go because lawyers are normally very busy. So, but I am extremely happy that we have organized this program, invited erudite speakers to do this extremely key topic for society as a whole, for a criminal lawyer, for academia, for law students. The understanding the concepts of bail is very, very important. It is bread and butter. So we've had such a distinguished panel, Professor Gaul, Mr. Mathur, just Ram Karsh. I don't think anybody could have asked for anything better. I only hope the attendees and the students have benefited from it. I must, with folded hands, thank both our speakers, Professor Kaul, Mr. Mathur, and also Honorable Justice Ramkumar. What a wonderful exposition of the law. Professor Kaul, you traced entire jurisprudence, evolution. For those who are interested, I have summarized I put the citations and the names of the cases in the chat box. You're welcome to take a look at it in your own time. Mr. Mathur, well, it is as if going back 1.5 decades, sir. I will tell you something about Mr. Mathur. Whenever you would go him, not a find provision. Will never tell you where the provision is. He says, "Jaake dhoond." नहीं मिलता तो कोई बात नहीं, जाके ढूंढ. That जाके ढूंढ was actually a challenge, and you would read up, you would reach that CRPC. If you did not get that CRPC in the court, he would come down on you like a ton of bricks. We would look forward to sessions wherein he teach law as he saw it on Friday evenings and on Saturday evenings, depending on whether the next day was second Saturday or not. Unlike other lawyers, he was not socializing on Friday evenings or Saturday evenings. He was in office till 9 minimum, and he would teach us, and there was nobody who was missing those classes. So thank you very much. It's as if going 1.5 decades. Of course, I had more hair on the head then, and wearing reading glasses. We are very happy to have members of the bar, senior members of the bar here. I saw a lot of them here. I must pay thanks to each of them for sparing valuable time. Ms. Sumiti, our program coordinator, thank you very much for putting this together. Dr. Ajay Sonavane, Senior Assistant Professor, Law Center 2. Thank you very much for all your technical support, for designing the poster, and for helping us in various other ways. I must thank the faculty members and staff of Law Center 2. I must thank our professor in charge, Professor Mahavir Singh, sir. Not only you thank your professor in the beginning, I have taken the liberty to do so in the end, because sir has immediately, at all times, whatever support was needed, he said, yes, you must do this. The moment I discussed the topic, he gave me his suggestions. Isko aise nahi aise karo, topic ko aise modify karo. He says bail is something people don't really know much about. So, like this, I thank all the students, all the attendees. Thank you very much for coming together, making this program successful. Thank you. And we look forward to seeing you again.
Professor Mahavir Singh, Professor Mr.